All right, hey people, Russ Jensen. So it's about 7:20 on the 10th day of January 2017. Now, I left off this previously talking about the fact that you are the lawful sovereign authority, that the sovereigns and the sovereignty, the government officials get their authority from you, delegating that to them. And also talking about the fact that you are the one Supreme Court that is talked about in Article 3, Section 1, Clause 1. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. Now, I have to make clear at this point, I always do when I have this conversation with people, is that it doesn't mean that you can create a courthouse in your office building, hold trials, hold court, okay? That United States Supreme Court, the one that everybody knows about, it operates 9 justices, the one that are having a big controversy over right now. That court is an inferior court, one of the inferior courts the Congress may from time to time ordain and establish. Now, your United States Supreme Court was created by Congress, the first Congress, in the Judiciary Act of 1789. Okay? Congress may from time to time ordain and establish. Congress has what? Power to do what? Make all laws which shall be necessary and proper for carrying into the execution the foregoing powers. Now, in Article 1, Section 8, Clause 10, 8 clauses previous to that, we have the Book Law of Nations. In the Book Law of Nations, we find at Book 1, Section 165, there ought to be established Supreme Courts of Justice wherein cases should be finally determined. Okay? That Law of Nations, every organization, every office in your government of the United States is found in that book. No offices that are not listed in that book, we don't have any. If it's not in that book, we don't have one. Now, it'll be under all kinds of different names, subdivisions, committees, but in general, you'll find every major office or delegation of authority or a type of activity for the government found in that Book Law of Nations. It's the one they operate by. It's what controls your Congress. Okay? Okay? Same book that we can access. Now, the Supreme Court of the United States, one everybody knows, 9 justices, they have limited jurisdiction. Now, this is what becomes part, and I'm not going to talk about it in this one because I want to keep this kind of short. We start talking about the types of law that are allowed, that are permitted, that have been authorized by your Constitution. And that's found also too in Article 3, Section 2, Clause 1. The judicial power, meaning the judicial power of the United States, shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made which shall be made under their authority. The authority of who? The laws of the United States, the people, under the laws of law and equity. Now, here once again, I get very upset with the fact that our educational system has failed us so well purposely. Now, you're reading that, Article 3, Section 2, Clause 1, after where it says under their authority, there is a semicolon. Now, what does a semicolon mean? What does it do in grammar for us? You know, primarily, the primary use and function of a semicolon, as most people understand it, is that it shows that the ideas in 2 separate clauses are related, but they are not the same. Okay? They're related by a nexus point of some kind, but they are separate. So the interpretation that you'll start hearing about when you start studying these things, you'll find out that there are uh, the area of arising under the Constitution, which is law and equity, and then we have another two forms of uh, law that are talked about, but they come after the semicolon. So law and equity are separate, although they're related to these cases affecting ambassadors, other public ministers, and consuls, to all cases of admiralty and maritime jurisdiction. So what we have is all cases affecting ambassadors, public ministers, and consuls. Now what are those? Those are government offices, aren't they? Those are functions performed by people in the operation and the day-to-day functionality of government. But there's also a semicolon there too, and then it goes to all cases of admiralty and maritime jurisdiction. So what that does, okay, that draws law and equity to the ambassadors, number of public ministers and consuls, but they are also the only ones that have the ability to be brought under admiralty and maritime jurisdiction, because they are subjects of the legislative authority of government to rule and to regulate its own performance. Also, too, I'll show this in my book, there are a number of cases, Supreme Court cases from that Superior Court, talk about the fact that admiralty and maritime jurisdiction are exclusive for the United States as a governmental organization. And in the Judiciary Act, they created the district and circuit courts, limited jurisdiction. They created the district courts of the United States, and the United States district courts are not the same thing. I've got another section on that. I've talked about it before a little bit. But so we have to understand that yes, you can create your own one Supreme Court, vesting it with your sovereign authority. Okay? And when we start talking about and understanding, studying common law and what it really is, you'll have a much better idea of how that really works, what happens as a plaintiff. In fact, that law and equity can only apply to people. Admiralty and maritime jurisdictions apply to fictions, to paper, to contracts, to commerce activities. Not the people in the commerce activities, but the activities of commerce itself, the tangible, physical items and contracts, the pieces of paper. Okay? That's the jurisdiction of admiralty and maritime. Cannot be applied to you as a living human being without your voluntary, intentional consent. And even then, it's not supposed to be brought upon you personally. Common law has all kinds of things for breaches in contracts. But the breaches go to the torts, the damage to the actual living person. Corpus delicti, the damaged party. And that's the difference between common law and your statutory admitted admiralty and maritime, is that in common law, the actual damaged party must bring the action. Admiralty and maritime, an agent of a piece of paper can possibly bring the action, okay? Because the breach in a contract in admiralty addresses the breach in the terms of the contract, the terms that were designated, the damage that then accrues to the commodities, the tangible physical objects that are not a living human person. Okay? And it's also limited specifically for use in the United States government. Okay? Now, what they're doing too in the territories, they've done that. They've set up district courts under Admiralty and Maritime jurisdiction in the territories. You know, and the Admiralty and Maritime jurisdiction for your district courts of the United States, which they don't have any operating right now that I know of. But those are the ones that are the federal courts that are supposed to be operating out in the states to deal with these issues of contracts. Because we have to have a forum to deal with a contract from the state of Utah versus a breach that was taking place in Arkansas, and so on and so forth. So that's what it starts to talk to about. That's why federal courts have to have some limited jurisdiction, but they're very limited in the scope of what they can look at, and it can't be at people. It has to be at paper, fictions, okay? Statutes which don't apply to living people, common law and equity. That's all that can be attached, applied to a living person. So, and I'm probably getting people confused now a little bit because I got a little bit off track. But what we have to understand now too is that there are only 4 types of law that are permitted, that are permissible, that are authorized by the Constitution of the United States of America and the Constitution of the United States and your individual republic, nation, state, your organic constitution. Your state constitution is only authorized at law and equity. They don't have permission to do admiralty and maritime in your state. Your state courts can't operate on that. That's why they've had to create this non-constitutional, legislative, administrative, statutory jurisdiction under the guise of a territorial rule or whatever. Okay? At law and equity, the only forms of law that can be brought to bear have jurisdiction, law spoken against a human living person. Okay? Now, in my book, I go through all that. In my next video I'll do tomorrow, I'm going to talk about that more specifically. We're going to start studying common law, what it really is, and so over the course of the next few videos is going to be that, what it is, what's the processes, what's the paperwork that we can use. There's a whole set of procedures in common law, just like there is in statutory law. Okay, so once again, you have to remember, you are the lawful sovereign authority. You're the authority that all things operate upon. Okay, without your consent, no authority for them to act. Okay, now we give consent in all kinds of ways. We're going to cover that in more detail in these other ones also. But you can bring to bear in Article 3 court the judicial power of the United States as one of the people to establish your court, to challenge jurisdiction, to give the other court permission to verify to you its jurisdictional authority, whether or not it applies in the instance that you are involved in. Also understanding too that the United States Supreme Court was created, legislatively created by Congress in 1789, the Judiciary Act. And also permission for that, authorization for that is found in Article 1, Section 8, Clause 10, Book 1, the Law of Nations at Section 165. Now, Section 164 talks about the inferior courts. The inferior courts shall be concerned with the revenue. Isn't that what happens? All your inferior courts, all your smaller, low-level courts, even your state courts, money, fines, aren't they? So I'm going to leave that one off here with everybody, and I'll post up a couple of these notes here. Important we start understanding what we're reading, understanding the importance of punctuation, grammar, syntax. I know it starts to sound like it's very complicated, but it really isn't. There's only a couple of things we have to pay attention to. But most importantly is just get this book, Law of Nations, start reading. Get your Constitution for both the state and your federal Constitution and read them numerous times until you start to get the flow of how they're writing things, and then stop and think about what's going on. Okay? They don't have permission to create a slave society. They don't have permission to regulate everything that you do. Okay? That probably one of my videos tomorrow, I'm going to show you in the Articles of Confederation where it states specifically that uh, commerce, movement of goods between states cannot be regulated okay, in the manner that they're doing it. Okay, and Articles of Confederation, perpetual, still in force and effect today. Okay, that's where they get a lot of their authority to do things too that they don't tell you about. Okay, all right. Have a good night. I'll talk to everybody later.